Welcome to MSL Presents A Question of Law. The topic for today's show is sexual harassment. Defining the boundary between sexual harassment, workplace banter, and harmless flirtation is difficult. For example, when someone says to a coworker, "You look great in that dress," or "You have a great body," or "Come on, Grandpa, we got a 2 o'clock meeting," or "You dumbbell, can't you do anything right?" Does that violate the law? In the half hour that follows, we will discuss what sexual harassment is, what remedies are available to its victims, employer liability, and preventative suggestions. Stay tuned. With the guests I'm about to introduce, I'm certain this will be an exciting half hour. Joining me today, Charles Walker, Chairman of the Massachusetts Commission Against Discrimination. Welcome, Chuck. Delighted you're here.
Thank you, Diane.
And Michael Coyne, the Associate Dean of the Massachusetts School of Law. Welcome, Mike.
Thanks, Diane.
And I'm Diane Sullivan, a professor at MSL. Chuck, let's begin by defining what is sexual harassment.
Sexual harassment is a crime that's defined both under the mass statutes and the federal that essentially prohibits solicitations or unwanted sexual advances and using them to further someone's cause. And I'm trying to break it down in layman's terms, but basically it breaks down in two parts. There's a quid pro quo and a hostile work environment. The quid pro quo is where you have management using the power or the leverage of their position to elicit sexual favors. And the hostile work environment deals with co-workers and creating a hostile work environment. Both are actionable under both the federal and state statutes.
Thanks, Chuck. And just to summarize what I believe you said, there are then two forms of sexual harassment. The first one being quid pro quo, meaning this for that, or sleep with me tonight if you want that raise. That would be an example
Correct.
of quid pro quo. And Mike, then there's hostile work environment.
That's correct, Diane.
I wonder if you could define for the audience what we mean by hostile work environment.
If we look at the graphic that we prepared earlier, Diane, the question is whether the workplace is in fact full of intimidation, ridicule, or insult that it's so sufficiently severe or pervasive. And that's the key phrase, sufficiently severe or pervasive, so that it alters the conditions of work or the employment conditions.
Okay, thank you, Mike. Chuck, I wonder, must sexual harassment take the form of sexual advances or some other type of communication with sexual innuendo or sexual content? In other words, must the harassing conduct be sexual in nature?
Yes, that's a primary element of sexual harassment. It has to relate to someone's sex. There has to be some type of and the behavior exhibited has to be sexual in nature.
Okay, thank you, Chuck. Gentlemen, there is conduct that I think everybody that's listening would recognize immediately as being harassment, physical coercion or intimidation that's intended to get a victim to submit to sexual favors. But what about things like derogatory comments, jokes, or really vulgar statements? And I wonder if we could talk about this by way of illustration. Mike, I prepared something for you. Assuming that you were to come in tomorrow morning and in your inbox you find the following. I wonder if you think that would be actionable as sexual harassment.
When you look at the cartoon or the like that's presented, the question becomes, and these types of things circulate in businesses all the time. First of all, I'm not a triathlete, and that's not my body as much as I might like to be attached to my head. But the question becomes, is it based on my sex that this cartoon and the like was sent to me? If so, it could be considered part of the material that might make a claim for sexual harassment. But the problem with it is that a single incident rarely is going to make the case for sexual harassment. I, myself, frankly, don't even find this offensive as much as I find it humorous. And the law requires not just that a reasonable person would find it offensive, but that the person who received or who is the target of the harassment would find it offensive as well. And so in this instance, this cartoon, myself, I don't find it offensive. Although if one looks at the little note that's was attached to the side, Mike, I'm going to get you in or out of your Speedo, some others would well find that this is an invitation based on my sex to perform things that I would be unwilling to do, and that it could start to make the case for sexual harassment, but a single incident rarely is going to be sufficient to form a claim for sexual harassment.
Chuck, would you share that view?
Yeah, exactly. You know, you have, and another thing I just want to add to that is, you know, who's it from? And it really makes a difference if it's from your manager or someone that has control over you, or if it's whether it's from a fellow employee. At which point, you know, that's when the quid pro quo, the hostile work environment analysis becomes important as well. But yeah, generally a single incident thing is going to be very, very, very difficult to prove. I wouldn't run down to the MCAD holding just this one with nothing more to show. It would certainly be evidence, but it certainly would not carry the day for you.
It's not enough to rise to an actionable claim for sexual harassment.
Yeah, I get with this and nothing more, probably not.
Probably not.
The one thing we do know, Diane, is that with the recent Supreme Court decision, whether a man or a woman sent this to me is irrelevant now. The question is whether the advance is welcome or unwelcome, not whether the offender is a male or a female, and that is no longer an issue.
But it clearly does make a difference whether the sender is a supervisor or a colleague.
Yeah, and let me just add something to make it actionable. This would be actionable. This by itself, if Mike would suddenly say, this is terrible, throw it away, email everybody, don't ever put this garbage in my box again. Manager finds out that he objected to it, and Mike comes up for promotion, and she says, no, I'm not going to give it to the guy because he has no sense of humor. Well, then I would say, then it becomes a little more actionable because this serves as part of the basis for why he didn't get the job, and it was based upon his sex.
I have another graphic for you. Chuck, I wonder if you'd take a look at this. Assuming I come in tomorrow morning and this is in my mailbox. And as you can see, it's a picture of 3 women in their underwear. And attached to it is a note that says, are you as good looking in your jockeys as they are in theirs?
Signed Mike.
Signed Mike. Who's clearly my supervisor, Chuck.
I'd say this is again, I would apply the same analysis. Quid pro quo, hostile work environment, that in and of itself may not be actionable, but you know, you have to see, it remains to be seen what transpires. But also, you know, this could be evidence of creating a hostile work environment. It could also be evidence of trying to solicit sexual advances, a quid pro quo, something for something. But in and of itself, it would be hard to just say, yes, sexual harassment, you're liable, $250,000. I wouldn't say that, but you know, you need a little more indicia.
What if the next day I come in, and this is in my box now, it says, warning, you're looking at a high-performance woman. I can go from 0 to bitch in 2.1 seconds. Comes the next day after this. We have enough now?
High-performance woman, I go from 0 to bitch in 2 to 1 seconds. This is more, this borders more sexual discrimination more than sexual harassment. I mean, it does create, again, maybe a hostile work environment, but here they're clearly looking at you as a woman, and they're treating you as a woman.
Thank goodness, I should say.
Well, that's good, but they're also looking at you know, as this bitch thing, and so they would never look at a man in this context, and so the disparate treatment is based upon your gender, not so much based upon illicit, unwelcome sexual advances, which is part and parcel to a sexual harassment claim. So, it's actionable, but either under gender discrimination or sexual harassment, it's a little more questionable.
Okay, thank you, Chuck. Mike, I wonder, can sexual harassment involve conduct such as berating or screaming at subordinates?
It can, provided that there is some sexual content or some basis that you are being discriminated against, as Chuck pointed out, because of your sex. The fact of the matter is I could probably call you an idiot, but if I didn't call you an idiot B, then that might be actionable. What the court says is when we're looking at these, and if we look at the graphic, when we talk about using words with sexual content or connotations, the Supreme Court tells us to use common sense. To try and take these situations and really carefully distinguish between acceptable teasing that goes on in every work environment and truly abusive behavior. And the fact is that truly abusive behavior, at least to be sexual harassment, has to have some type of sexual discrimination or sexual orientation to it in order to make it more actionable. There's abusive bosses in every work environment. They may be violating other laws, but they're not violating sexual harassment laws.
So if I say to an older colleague of mine, come on, Grandpa, we got a 2 o'clock meeting, that would not be harassment?
Now, that would be more age discrimination, but no, I think you'd have a harder time making that a sexual harassment type of a case.
Equally wrong, but a different law.
Yeah.
What about things like sexual favoritism? Can men and women alike bring a sexual harassment action because they feel they're being denied a promotion because of sexual activity that's going on in the company between a supervisor and a colleague of theirs?
This is a more difficult question that we talked about a little earlier today. Normally, I think the courts would find, and this is, when Chuck and I are starting to talk about these issues, a lot of this is still quite unsettled area where we're trying to figure out where the Supreme Court's going to go. There's 2 very important cases that the court will resolve this spring that will help clear up some of these issues, but a lot of this is really gray. I would say that the sexual discrimination or harassment has to be directed at the employee in order to try and recover under the Act. You cannot make a claim on the basis that because you didn't have the opportunity to sleep with the boss and get the promotion, that somehow your claim is actionable. That's my feeling on it, is that the sexual harassment or discrimination must be directed at you in order for you to recover. Otherwise, what you would be allowing is every employee in the company to have some form of claim of harassment or discrimination based on a consensual relationship that would exist between the supervisor and a subordinate.
But what's the matter with that? I mean, supervisors should not be sleeping with their subordinates.
Well, we have a supervisor at work that sleeps with his subordinate. He happens to be married to her. I mean, people meet at work and get married all the time. If we run our own offices at work, we will find that a number of those folks met at work and got married and now either continue to work together or work elsewhere. But the work environment is where most people meet at one point and perhaps form relationships. Some businesses have taken your position and outlawed any form of intra-company dating. Do you want to go that far?
I probably don't want to go so far as outlawing intra-company dating on a whole, but I think a policy that supervisors ought not to be sleeping with their subordinates probably makes sense in today's environment.
What's critical in the analysis as well is the tangible benefit that's being derived from it. So if, let's say, one employee sleeps with the boss and gets the promotion and the employee that was solicited earlier and rejected the boss didn't, then you have to look at, and the person that didn't get the promotion brings a sexual harassment claim. The question then becomes, well, did she derive a tangible benefit, or was she denied because of her rejection of the boss's advances? And the answer to that would be, well, it depends, if that's what the reason was, but you also have to look at the qualifications. If the person who slept with the boss turns out to be more qualified as well, then it kind of like washes the solicitation and the actual illicit and adulterous act of the manager. I mean, but you have to look at all of it. But yeah, the answer is it could be, but you can't say definitively whether it is.
Thank you, Chuck. Chuck, one more question I have for you. Are employers liable for sexual harassment of their employees by third parties or customers, for example?
They can be, absolutely. And under the right circumstance, the guy comes in, he's the water bottle distributor, and sees the receptionist always making comments on her breasts or stuff like that. The standard is, did the employer know or should have known? It's a reasonable person type of a standard, and if the employer was in that kind of position to remove that and it was unwelcomed, then the employer could find themselves in a liable position.
Okay, thank you, Chuck. Mike, is economic harm or job loss necessary for a plaintiff to prevail in a sexual harassment action? And what I'm thinking of is, will Paula Jones' action against President Clinton ultimately fail if she's unable to prove that she was disadvantaged in the workplace?
That is one of the issues actually before the Supreme Court on a different case, a case that came to us from Florida, where their employee must show economic loss as a result of the sexual harassment or the hostile or abusive work environment. So it's somewhat unsettled. But I do believe that they're going to find that there has to be some job consequences as a result of the sexual harassment that the person has suffered. And the situation with Paula Jones right now is that she can't show she was denied a promotion or lost any financial benefits as a result of the encounter with the president. And what she's trying to prove is sort of the situation you referred to earlier, which is that other employees who slept with the boss received more beneficial treatment. And therefore, she has suffered adverse job consequences as a result of rejecting the advances. And if that's the case, that is actionable, and she may be allowed to recover. There has to be consequences. The question is, what must those consequences be? Must they be financial? Could they be emotional? Could they be psychological? And I think many plaintiffs will be able to make the case that they're one of those three.
Where do we draw the line, Mike, between unwelcome sexual conduct and things like non-offensive flirtation that goes on every day in the workplace?
Who knows? I mean, that's the problem. We don't really know. In doing some of the research on the show, I found some truly offensive and outrageous behavior out there that actually surprised me, that was still going on in 1998 in the workplace. Words such as slut and others even quite more offensive than that still being used in the workplace simply because the person you're addressing those comments to is a female. We don't have the equivalent words that we can call a male. But other, more outrageous behavior is still going on, and that's the easy part of it. When we're way out there, away from what we would do with our mother or our sister in the manner in which we would talk to our family members. When we're way out there, it's easy. The problems come in the question you ask. You and I see each other and talk to each other every day. We joke around. We rarely joke around in the area that we're talking about today, but other people do. Other people have different relationships and can banter like that. And that's where the problem comes in, is that it's easy at the two extremes. Really good behavior, be polite, follow the golden rule, and the other end of the extreme where we're really offensive and vulgar and crude and boorish behavior. It should be prohibited. But the middle, the court tells us, use common sense. Look at what took place in context and try and figure out what appropriate behavior would be.
Chuck, when you're determining whether conduct is severe enough to rise to the level of sexual harassment, do you use an objective standard or a subjective standard, or both?
I use both. I mean, what may be totally innocuous to me may not be innocuous to the recipient of it. You know, some people fall apart to be called, you know, a bitch or a bastard, or you know, because it very well may have some type of it may dredge up some very, very personal issues in that person's life. And if the employer knew about those certain heightened sensitivities, that really it does have an impact. And so you can't just apply an objective standard, a reasonable person standard to every case, nor can you just rely upon a subjective standard as well, because some cases merit, you know, come on, that, you know, you shouldn't have got that kind of upset over something like that.
Just isn't reasonable.
It just doesn't sound reasonable.
Thanks, Chuck. I wonder if you could take a moment, and for the audience, if you could summarize employer liability for sexual harassment actions brought against a company. The summary I would give is that under Title VII of the 1964 Civil Rights Act, as well as under the 151B of the Massachusetts General Laws, strictly prohibits, as well as this new sexual harassment policy, which requires employers to post information, that you have to conform yourself to the best ideals of your job. You really want to pay attention to your workforce, to their needs, and if there's ever a question or a problem that arises with respect to someone's sex being solicited, either by a manager or by a fellow employee, they need to pay strict attention to that, address it forthrightly so that they can avoid liability. Liability can exceed, at least at our agency, over $250,000 for sexual harassment in those special cases. So it's and I will say this, of the four major types of cases brought to our agency, sex, race, disability, and age, sex still reigns the highest type of case that's filed with our agency
and it's been that way for the past 6 years.
Thank you, Chuck. Mike, what remedies are available to a woman or a man who is claiming sexual harassment?
Well, as Chuck pointed out, there's both remedies under state and federal law. The principal thing to remember in pursuing these types of claims is they must be done promptly. A lot of times people think they have a year or 2 years in which to file claims, but the agencies require that these claims be pursued fairly aggressively and fairly quickly after the offensive behavior.
180 days in the Massachusetts law.
And then we are talking about monetary relief, significant monetary penalties for this type of behavior that an employer doesn't pay attention to and doesn't prohibit and stop right away. From an employer's standpoint, the obligations upon the employer to curtail this type of activity are significant, and the penalties for failing to do so are quite severe.
Let's summarize what we've reviewed so far today on the show with the following hypothetical. Assume a male supervisor is continually asking a subordinate out for dates, and she refuses. When he's alone in the office with her one night, he starts to ask her questions about her sex life. And from there it proceeds. He ultimately grabs her and kisses her, and she walks off the job. What type of claims could be brought? Chuck, you want to get us started?
Big claims.
Big claims.
Well, sexual harassment is clearly going to be the one big claim there. The sexual advance you have the a manager subordinate element there, so you have a quid pro quo, you have a solicitation for sexual advances to further your job, which might impact your ability to be advanced in the company. So you have clearly a sexual harassment claim burgeoning. I don't know if that answered your question.
It does. Mike, do you want to add anything to that?
No, I mean, what you've set up, Diane, is certainly at least a situation where you have created this pattern of activity that could be considered sufficiently severe, pervasive, that it's created the hostile or abusive work environment, which really has to be avoided under the Act.
Yeah. Mind you, there's always two sides to every coin. They say the victim could have created that situation. They could have almost solicited the manager. I can't come up with the right scenario, but there's two sides to every coin. You just can't just look at one scene and just say, okay, sexual harassment. You've got to know the underlying facts, what prompted that.
And you would investigate
situation.
that.
We'd investigate that and get all the facts surrounding. Clearly, his side may say something completely different, that he was the one that was enticed and solicited and propositioned, if you will. So you have to look at both sides of the coin, and you got to weigh it. It's always a balancing, and there's always a credibility issue. Mm-hmm. But and that's why it's so difficult to say yes liability, no liability, because there are two individuals, two families, and a whole society that's going to be looking at something that's looked upon as bail in a workplace.
Who administers sexual harassment law, Chuck?
The Mass Commission Against Discrimination enforces it. The legislatures pass it, and and so we enforce it to the best of our ability. So as well as the Equal Employment Opportunity Commission, or the Feds.
Thank you, Chuck. Mike, what is the best way, in your opinion, to prevent sexual harassment in the workplace?
The first thing is to have a strong policy which prohibits it. As Chuck pointed out, under Massachusetts law, every employer of more than six or more employees must have a policy against it, and should be clearly articulated to all employees. The types of things that we saw today, frankly, should be prohibited. There should be a policy against the display of cartoons and the little sexual stories that at times are circulated by email and the like. And an employer, a prudent employer, will discourage, and not just discourage, but probably prohibit any form of sexual content or speech that might be involved in the workplace. A strong policy clearly articulated to the employees is a good start. And also, from management especially, you lead by example. If you don't do it and you tell your employees you don't tolerate that type of behavior, it's not funny, it's not appropriate to talk to men or women pejoratively, then what you'll find is you'll improve morale and performance and also avoid significant liability under the Act.
Chuck, in a sexual harassment policy guide, what type of things should be included in an actual guide itself?
Well, first you got to know who you go to. Well, a number of things. The guide should spell out what to do if you're confronted with sexual harassment. It should outline, the procedure. It should be more than just instructive, but also educational. It should define sexual harassment in the workplace. It should also identify who in the workplace to go to, your human resources individual, to help investigate this thing, someone impartial who will take it on and deliberately look at what happened, what transpired. It should also identify the state and federal agencies whom you can also address in the event you want to seek it, you want this enforced. And it should also indicate that you're not required to go to the human resources individual, but and then these state and federal agencies have certain timelines within which to bring your sexual harassment claim. So those 3 or 4 basic elements.
Mike,
As well as, I'm sorry,
that's okay.
I think the employer would do very well to state, and it could be viewed as self-serving, but a strong and definitive statement of zero tolerance for this in the workplace. That's really first and foremost.
Great
what the policy should
suggestion.
state.
And it may be self-serving, but it's certainly going to help if these situations arrive that the employer at least tried to discourage the behavior. It'll at least help from the standpoint of minimizing liability. Won't preclude it, but may minimize it.
Assuming that an investigation reveals that sexual harassment in fact occurred, what must the company do to shield itself from liability?
Well, under a quid pro quo or managers, it's almost like a strict liability standard where you're automatically held liable. So the best thing you can do is try to mitigate some of your damages. I would immediately I would separate the parties. I would require training of not just the individual, but also of all my managers. I would take a proactive stance in trying to ameliorate the circumstance. Don't put a Band-Aid on it, but to prevent it from happening in the future. Discipline, suspend, even fire if it's necessary under the circumstances, the particular employee who did this action. Whatever you do, do not treat it with short shrift or with gloves, because it's a very, very serious offense, and that's why the law is passed so that employers take the lead.
Isn't that the biggest mistake, in fact, companies make, is not treating sexual harassment seriously?
That's absolutely right. And Mike said something earlier, and I have to say that MCID does not have authority to issue punitive damages, punishment damages. We issue emotional stress damages. Emotional stress is driven up by the inactivity or the omission to act by the employer when something like this is reported. She's lying. Oh, no, that didn't happen. I know it didn't happen. Why don't you just go on back to your work, Shay, and we'll talk to somebody, and they don't do anything about it. That'll drive the emotional stress damages up because it erodes the confidence that you have in your management's ability to protect you and to take care of things in the workplace when they happen. It draws upon your integrity as an individual, and so that's what you should be cognizant of as an employer.
Thank you, Chuck. Regrettably, we're out of time. Chuck, Mike, I thank you so much for a very informative half hour. I hope you'll come back and join me real soon. And to our viewing audience, until next time, be well.